Ms. Dilligard.
Good morning, Judge. How are you?
Well, I'm happy to see you. Didn't know you were still rattling around out there.
Oh, yeah.
Mr. Banks, when Ms. Rivers gets back out here and her equipment is fired up, we're going to bring Mr. Hairston out. He's not dressed out yet because the clothes just got here, but there's some things I want to get on the record, like the offer, just a few more things about representation. And assuming we're a go, then while we're waiting on the jurors, we'll get him dressed. Yes. And I can talk to you about the format of voir dire, things like that.
Sounds good. Thank you, Judge.
You're welcome.
Give the court a heads up, just for the record. I'm going to ask for a continuance.
Okay.
For Mr. Hairston. I just need to put it on the record and.
We will all get on the record the things we need to get on the record.
Sure.
And we'll see where that takes us.
Okay.
Ms. Rivers, I have a copy of the state's witness list for you.
Okay, great. Thank you.
Uh-oh, now they're rescinding their witness list?
No,
Here we
I
go.
haven't sent it. I have one name that I do need to add.
Okay, we'll do it. We'll get all this on the record. I want,
That's okay.
okay. When Ms. Rivers says she's ready, there's cords flying around. So wait till she gives you the thumbs up.
No, YouTube.
Oh, good.
It's working.
But he's no longer, you reached out to us.
Anyway, it's ridiculous. Just the oldest.
Oh, whether the guy's still working. The Lord. That is the Lord. Who Ellen and him were talking about. I mean. He passed that. He kept him on, so they got you look real live.
We're good? Okay, we're ready for them.
Shut them off.
All right, good morning, everyone. We're going to get on the record in 23 SC 188908. It's State versus Hairston. Mr. Hairston is here. Good morning, sir.
Morning, Your Honor.
He is here with Mr. Banks and Mr. McCrimmons, his legal team. We have Ms. Willingham here for the state. Ms. Willingham, is Ms. Dilligard going to be partnering with you today, the whole trial, or she's here with Ms. Smith?
It's going to be Ms. Dilligard and Ms. Smith.
Well, fantastic. All right, just need to know who.
I need another one.
Well, you got Rios and Wood behind you. Maybe you can draft them. All right, we've got three prosecutors here. Mr. Hairston, there are a few things that I want to get on the record, and Mr. Banks told me there are some couple things he wants to get on the record. If after we sift through that, I determine we're still going forward with your trial today, then we'll take a quick pause and Deputy Gordon will help you get dressed out. You're not going to be dressed like that if we do go forward. But I want to hear from Mr. Banks, see if Ms. Willingham has anything she wants to add. And then a few things I want to get on the record, and then we'll figure out what we're going to do, okay? Mr. Banks, I'll start with you.
Thank you, Judge. Good morning.
Good morning.
On behalf of Mr. Hairston, I would be asking for a continuance of the trial in this matter. As the court knows, I came into the case late May. I think I got discovery around June or July. It was, for the most part, complete, although I've had an open line of communication with Ms. Willingham. She's been very diligent on behalf of the state in getting me everything that I need and pointing out certain things that I didn't understand about the discovery. And so I certainly appreciate that. Having said that, as the court knows, I've been working with Mr. Harrison for less than a year now. We did have the opportunity to have him evaluated. I know the court, prior to my entry, Ms. Miller, I believe, filed a motion with the court to declare him indigent. I think the court granted that motion. And so my first request to have him evaluated for criminal responsibility was going to be by a state-paid lawyer. The court.
Well, not lawyer, but state-paid medical professional.
Medical professional,
Yep.
yes. And so that happened. A state-paid medical professional appeared with Mr. Harrison, and unfortunately, that didn't go forward. He refused it. I think that medical professional.
He, meaning your client, refused it.
He did. And I certainly understand why. I think that medical professional was the same medical professional who evaluated him for competency. And so maybe arguably from his perspective, some bad blood. I then made it a point to ensure that the family understood and that he understood that he couldn't just pick and choose who evaluates him and that they would have to pay for an expert. And so before the court found out about the refusal, I lined up a medical professional to evaluate Mr. Hairston. Without going into the details of that evaluation, Judge, I will just say that that evaluation is what it is, and we can't use that evaluation to support a defense of his. As a matter of course, if I am representing a defendant, not just Mr. Harrison, but any defendant for that matter, and I have a defendant evaluated, and for whatever reason I can't use that evaluation, I would seek another opportunity to have the defendant evaluated again by another provider. I mean, this is something that I was I would do in a medical malpractice case. Oftentimes when there's standard of care issues, you try to find a medical expert to support the doctor's standard of care. And sometimes the care is unfortunately bad enough where you don't get any support and you continue to send it out to have someone support the doctor. I would do that in this case, and I haven't had time to do that. And a part of the reason why I haven't had time is because the family of Mr. Harrison have been, I mean, the funds have been an issue. Yesterday evening, I received a text from his mother who indicated that she had funds and had secured an expert by the name of Andrew M. Gothard. He's a licensed psychiatrist. He's locally here in Atlanta, and he's prepared to evaluate Mr. Hairston as early as this Wednesday. And so without getting into the details of what our strategy is, I do believe that on behalf of Mr. Hairston, his strongest defense, if it existed, would be through that of a medical professional saying that he suffered from some delusional thought and or some mental defect that failed, that gave him the inability to appreciate right from wrong. And so without an expert, I don't have it. I need him to be evaluated again. For those reasons, I would respectfully ask on behalf of Mr. Hairston a continuance, given the time that I've been on the case. Thank you,
Okay.
Your Honor.
Thank you. One question before I turn to Ms. Willingham to get the state's response. Other than that, my impression is that you feel fully prepared to go forward. You're not saying I need a continuance because I'm still trying to figure out the name of the lead detective, or there were 5 witnesses that my client has identified and we haven't been able to find them. I want you to be able to make the record that you want to make, but to date, you've never flagged anything like that. It has been a quest for an expert who says what you need the expert to say.
I think that's a fair representation.
Okay, thank you. Ms. Willingham.
Yes, Your Honor. Others in here, but. The state would object to a continuance at this time, Your Honor. This is a 2023 case, and this issue has been discussed with multiple attorneys. This has been at issue since the inception of this case. And at this time, I feel that the defendant has had more than enough time. I understand that his family is now coming forward and they found someone to pay, but we've had this since 2023. So those options were available then as well. And I understand that Mr. Banks is new to the case, or is newer to the case as opposed to some of the other attorneys that have been on it. It's still the same issue that we've known about as being an issue in this case from its inception. So at this time, the state would object and we would ask that we still move forward.
Okay, and the state's ready to move forward?
Yes, Your Honor, the state is ready.
All right. I'm going to deny the motion for continuance. Mr. Hairston has been evaluated at least twice, and the findings aren't consistent with what, as Mr. Banks said, would be the most persuasive or compelling defense. But I don't think it's appropriate to say, well, let's just keep trying until we find a doctor who says things that are more supportive of the defense. I don't know that we'd ever find a doctor who says that. We might, but then we just set up this battle of 3 experts said Mr. Hairston is now competent, and at the time of the alleged incident was able to tell right from wrong, was not operating under a compulsion or a delusion, et cetera. So we've passed that point. And the medical professionals who took the time to work with Mr. Hairston and ultimately when Mr. Hairston was willing to interact with them, when he gave them his time, concluded that the support for that type of defense isn't there. And I don't think it's appropriate to pause these proceedings yet again so that Mr. Hairston can try yet again to either say the right things to a doctor or have a doctor say the right things. I'll note that there have been multiple evaluations and we have paused proceedings before to ensure that they occurred. Ms. Miller got the ball rolling as Mr. Hairston's very first attorney. So the process has been ongoing for a while. And I know we delayed trial. We continued at Mr. Banks's request. So this is during his almost 1-year tenure, 9-month tenure, because he was at his client's request doing extra research on what I'll call the expert side in terms of certain theories of defense that he shared with me on an ex parte basis, which means Mr. Hairston, Mr. Banks talked with me about a defense theory outside the presence of the state. So I'm not going to go into what that theory was, but he articulated it, I understood it, and for that reason I said, here's more time. But I shared with Mr. Banks, this would be the last allocation of time, and we've reached that point. The other thing I want to get on the record is that I find, again, today, and we discussed this on Friday morning, that Mr. Banks and Mr. McCrimmons are prepared. They are thorough in the work they do, and I find that they have had more than enough time to master the record before them in terms of the discovery, the evidence, et cetera. I'll note that the defense has proposed its own witness list. They have dived deep enough into the discovery that they identified 2 Atlanta police officers who don't appear on the state's witness list, and they've flagged them as potential witnesses. They may call, they may not, but that to me is a marker that the defense is familiar with what the allegations are and what the evidence is, or maybe for the jury, so what's in discovery, and they're prepared to move forward. And that's what we're going to do this morning.
If I may just briefly.
Sure.
And not to belabor the motion to continue, and I'm not asking this court to reconsider its position. I just want to make sure the record is clear that when I got on the case, he had been evaluated for competency. He had not been evaluated for criminal responsibility. And so when I got the file, not that I'm aware of, that he had been evaluated for criminal responsibility. And so when I got the file, I noted that I talked with Mr. Hairston, and that is what I sought for him to be evaluated for. And so I only think that only one doctor has evaluated him for criminal responsibility, and that was one that he hired. And so that I just wanted the record to be clear about that.
Fair point, accurate point. Of course, as you pointed out in your initial comments this morning, there were 2 goes at criminal responsibility, but the first time Mr. Hairston declined to engage with the professional. So through your efforts, 2 different evaluations for criminal responsibility were lined up. One of them, Mr. Hairston declined to participate in. And then through his family's support, you were able to find a doctor of your own choosing. That doctor came back with results that you're saying don't support one of the theories you want to advance. It's not a report that I've seen or that the state will ever get. But my point is simply that there has been time for these things to be done. And we're past the point of saying, well, let's redo and see where we get with another swing at that. Ms. Willingham, I need you, please, to state on the record what the state's offer is. If Mr. Hairston wanted to resolve the case today by entering a plea, what is it that the state would recommend, and to what would he be pleading?
Your Honor, if the defendant entered a plea today, he would be entering a plea to the indictment. The state's offer would be life. So with that, Your Honor, he would be entering a plea to the to the murder, the malice murder, the aggravated assault and the felony murder counts. As to the possession of a knife during the commission and the possession of a firearm during the commission, since the state's offer would be life with the possibility of parole, we would move to not cross those counts.
Okay. So, Mr. Hairston, there were some technical details as to what the state's offer is, but in essence, you'd be pleading to the most serious charge in the indictment, which is murder, and the state would be recommending life, which is the lowest sentence you could get if you're found guilty in this case. Your exposure, if you're found guilty, and these are all ifs, is life without parole. That is a legal sentence that the state might advocate for and that I could impose if a jury finds you guilty. If you enter a guilty plea, the state would be recommending life, which is a parolable offense. It's not parolable for a long time. I don't want to mislead you that the long time you've already been in would mean, hey, you might be paroled next year. You would, of course, get credit for all the time you've been in towards that calculation of when you're parole eligible. But do you understand what the state would recommend if you entered a plea today?
I believe so, Your Honor.
Okay, well, if you have questions, let me know and I'll do my best to answer them.
You said it's parolable?
Correct. If you plead guilty to murder or a jury finds you guilty of murder, there are 2 sentences that you can get. One is life with the possibility of parole. The other is life with no parole. Those are both legal sentences that the state could argue for and that I could impose. What the state is saying, it's a small benefit, but the benefit the state is offering you, should you choose to enter a guilty plea, is that they would advocate for life with parole. If you go to trial, I don't know that that's what they'd advocate for if you're found guilty. Of course, if you're found not guilty, you're done. We don't talk about sentences. But if you are convicted, then there are those 2 options, life with parole, life without parole. A plea would mean that the state's not going to argue for life without parole. They would say, Mr. Hairston's accepting responsibility. The family doesn't have to go through the difficulty of watching the trial and reliving their daughter, their sister's passing, etc. And in exchange for that, the state would recommend a sentence of life with the possibility of parole, which is still a very long sentence. I'm not pushing you one way or the other. I need to make sure you understand the difference between working the case out now, and then the potential risk if you go to trial. Do you feel like you understand that?
What is life with the possibility of parole?
So you would be eligible for parole after you served 30 years in custody, including the time you spent. So if you've been in since 23, you've done 3-ish years, you'd get credit for those 3 towards the 30, and you would be eligible for parole, not guaranteed parole, but eligible for parole at the 30-year mark. Life without parole means, if that's the sentence you get, that you are in prison for the remainder of what they call your natural life while you're alive. You feel like you understand the difference between the two?
Yes, Your Honor.
Okay. Do you want to talk about the state's offer with Mr. Banks and Mr. McCrimmons?
Please.
Okay. I'm going to let you guys go back and we will pick back up when you return. Last name? Oh, Mr. Daniels. Hey, good morning. I don't mean to speak for your lawyer, but Ms. Smith, my understanding, I'm sorry to interrupt, is that you and Mr. Majeski have reached a resolution in the Charlie Daniels case? And we're just looking for a plea date?
Yes.
Okay, I'm gonna look the case up, Mr. Daniels. Hopefully that's not news to you, but Mr. Majeski had reached out to my office to say that he believed your case would be resolved. Are you surprised to hear that? No, okay, good. I'm looking to see, I don't know what the date is, but if you'd sit tight, I'm gonna send a message and see if we know what day you would need to be here with Mr. Majeski to work that out, okay?
I came Friday, so I took off work Friday. They told me to come today, so I took off today. So it's like, my job is like a state because I'm taking too much time off.
Okay,
I'm thinking that today, but my understanding was today we going to resolve it.
okay, that was not my understanding, but
He said Friday that you supposed to got back with him, and he said you never got back with him to sign off on something.
okay. I don't think I was supposed to get back with him, but I'm gonna let you and Mr. Majeski sort that out. Let me see if I can find out the day that you're actually needing to come back here. And I'm sorry this has been disruptive for your work. That's more of a conversation for you and your lawyer? Okay. Ms. Smith, Mr. Daniels case, what is it a negotiated resolution? Is it, pardon me?
Well, it has a certain time, he's already started.
He's done, so Mr. Daniels could appear virtually for the plea.
That's correct.
Okay, so Mr. Daniels, tentatively, it's scheduled for this Friday, but it depends on how this trial that I'm about to start is going. But based on what your lawyer and the prosecutor have negotiated, you could probably appear on Zoom if there is a quiet place you can be, whether it's Friday or sometime next week. I can't give you a firm date because we also need to make sure your lawyer is available. And as you know, he's a busy guy bouncing between lots of counties. So the best I can tell you is maybe Friday. And you and Mr. Majeski can talk about whether he wants you to be here or if he's okay having you appear through Zoom. I'm okay with that. You can tell him that, okay? All right. You too. Ms. Rios, are you ready to go?
Oh, yeah.
When you're done chewing. Ms. Rivers, you ready? All right, we're back on the record. Mr. Hairston, do you feel like you understand what the state's offer is if you decided to enter a plea in your case? Okay, is that something you want to do, or should we order up the jurors? Well, what I'm going to do is order up the jurors because I don't want to keep them waiting or us waiting. You should continue to talk with your lawyers. Ms. Willingham, this offer of life with the possibility of parole, does it stay on the table or does it have an expiration point?
That offer will expire.
And when you say impanel, do you mean we select the jury or I actually swear them in? Because one will happen today, the other will happen tomorrow.
Judge, when we swear them in.
Okay. All right. So, Mr. Hairston, you and your lawyers can continue to think about this option of pleading with a recommendation from the state of a sentence of life with the possibility of parole. That offer the state is keeping open until basically tomorrow morning. We'll pick a jury today. Tomorrow, when the jury that you've helped select arrives, one of the first things I do is swear them in. I give them an oath. They're going to get an oath today. That's not the one I'm talking about. It would be something that we do tomorrow morning. At that point, if you have not opted for a plea, then the state is withdrawing its offer. Understand? Okay.
I'm sorry, one thing I did want to also clarify, and I know it doesn't make that much of a difference, but, it would be life without plus 10 years. As possession of a firearm and possession of a knife have to be consecutive sentences.
True, if he's convicted, those can be suspended or probated. There are lots of options with those, but for your offer, you are dismissing those counts, so they're not at play. But it is true that if Mr. Hairston goes to trial and is found guilty of all counts, the maximum sentence could be life without parole plus 10 more years. Anything after life without parole is kind of academic, but I also, that's the ceiling. You could also get a sentence of life with parole after trial. I don't want you to think that that's not a possibility. What I was trying to emphasize is that either one, life with, life without, are possibilities if you go to trial and you're convicted. But I think you understand that. You've told me as much, and I've explained it a few times. So we're going to move forward. Mr. Hairston, I'm going to have Deputy Gordon get you dressed out in the clothes your family has provided, so you're not surprised. While you are back there getting dressed, I'm going to talk with your lawyers and the prosecutors, not about substance. Your lawyers filed a bunch of motions that we need to talk about this morning, but I'm going to talk a little bit about how jury selection works, because your lawyer sent an email this weekend asking about how that's going to go. I'm going to tell them that while you're getting dressed. When you come back out here, we will press on, okay?
Your Honor, would you like for us to stick around any longer, or maybe be excused?
If you don't mind waiting until when Mr. Hairston comes back, we're going to sign the indictment with the not guilty plea, et cetera. So I don't mean to keep you here too much longer, but.
How does that work? We're not open until Tuesday. What should we think?
Don't make travel plans.
Day, I was about to.
You're not free to leave.
Yeah.
Oh, entertaining.
All right. So Mr. Banks and Mr. McCrimmons, the way jury selection works in 8D is that we will have 51 jurors coming in. Oh, which reminds me, hold on. I want to make sure Ms. Nelson orders the jurors. I can tell her directly, hey, would you order the jurors?
Okay.
Please.
Okay.
Thank you. Yeah, I just sent you a little Teams thingy. We'll have 51 jurors. That is 3 groups of 17. That's the magic behind 51. They'll all be seated in the gallery. You all will switch sides of the table. I will ask them the questions that I sent you all yesterday. It sounds like we need to amend it, need to add, have you ever blacked out? You can explain the voodoo thing. Maybe I add that. But we'll talk about additions and deletions when Mr. Hairston's back out here. But that universe of questions, I ask the jurors and they answer, you've done this, but they just raise a card. That's it. They don't explain anything. You'll write down numbers if that's what you want to do. Then we take jurors 17 at a time. So we have a total of 3 groups. 1 through 17 will stay here. The others are free to take a break, leave the room, do whatever. The jurors will introduce themselves by answering questions on the back of the card. So you did not see in the questions I sent you, have you ever been a juror before? What do you do for a living? All valuable information, all of which you'll get through what I call the biographical questions that are on the back of those numbered cards. As we go through 1 through 17, they will introduce themselves. If they raise their card for hardship, I'll explore what that hardship is at that juncture. But eventually, all 17 will have introduced themselves. Then I'll turn to the state first for panel 1. And Ms. Willingham, Ms. Dilligard, Ms. Smith, one of those lawyers will ask whatever follow-up they have based on answers given. So if the state was really, really wanting to ask about marijuana, and I said, we're not going to get into that because that's not what this case is about, and that was not a general question, they don't get to ask the jurors, what are your thoughts about marijuana? Unless it's somehow the juror makes it an issue, like I run a marijuana dispensary. Oh, okay, what are your thoughts about legalization of marijuana? I don't think that's going to come up in this case, but you're kind of limited by what the general questions were. Your team will follow up with the first panel. So I expect you'll have less time with that panel because if someone was a victim of a crime of violence, the state will have covered most of it. And I ask you not to ask the same question, but there may be an angle you want to explore for a particular topic that you're free to. That'll take care of panel one. They get to go home after that. They'll leave the courthouse if they want, and they all want. So they'll be gone. 18 through 34, second panel, you go first. So again, they'll introduce themselves. I'll talk to them about hardship, and then defense gets to engage first. And so you'll probably have more questions than the state will, because just like you won't be asking the same question twice, the state won't be saying, well, tell me, where'd you go to college? Well, Mr. McCrimmon's already asked you that, and said you went to South Carolina. The state will go second. Those 17 people go home. At the end of the second panel, we'll do an informal head count of strikes for cause to figure out how deep we need to go into the third panel. If things are going well, we may only need to get to number 45 or 47. And I'll explain that I won't be asking jurors 48 through 51 to introduce themselves, not because we don't care, but we just may not need them as jurors. State goes first with the third panel, defense goes second, then those people leave. When everyone is gone, then we talk about strikes for cause. Once we know who has been removed for cause, if anyone, we'll know our pool of non-alternate jurors and our pool of alternates. And the goal is to have 2 alternates if we have enough jurors. And then it's peremptory strike time. State goes first. You can strike anywhere in the pool. We don't start with number 1 and say, so what do you say? I will say, state what's your first strike. And they may say, juror 5. And 5 is struck. Then I turn to the defense. And your first strike is anywhere in that pool of non-alternates. If someone chooses to not exercise, maybe by strike 5, the state is indifferent as to the remainder. I will still ask the state each time, well, do you want to use strike 6? Nope. Do you want to use strike 7? Nope. They can use any of the strikes. So they might at the very end think, oh my gosh, we were sure the defense was going to strike number 17 and they didn't. So the state uses strike 9 on number 17. That's fine. We take the first 12 in that pool for our non-alternates. If one side hasn't used all its strikes, there'll be more than 12 people left. Those remainders don't become alternates. They just aren't used. The alternate pool is fixed. So you know going in, you don't need to do some complicated math of, well, if I don't use all my strikes, then this guy might be a juror. Then we do the same process with the alternate pool. 2 strikes for each side. State will go first. They can strike anywhere in the alternate pool. We don't like number 41, strike 41. Then we'll have our jury.
Thank you, Judge.
Questions about that? Okay. The one other thing we do here that may be a little different than what you've experienced in other courtrooms is that jurors get to ask questions. They don't just raise their hand and ask in the middle, but at the end of every witness's testimony, I'll ask the jurors if they have any questions, and if they do, they write them down on note cards. I'll review the questions. If they are all real bland, like was it dark out, I won't have us huddle out back. But if there are any questions where I think, well, one side may want to be heard on whether that's a proper question, lawyers and I go into the back hallway, I show you the questions, and then you have a chance to say, you know, Judge, we object, that calls for hearsay. And if I agree, then I just don't ask that question. I don't tell, hey, juror 5, stop asking those kinds of questions. I don't ever identify, and we usually don't know which juror posed which question. But if they are proper questions, then I ask them of the witness. The jurors don't ever say anything to the witnesses. And you all get to follow up after the juror questions. So you get sort of a bonus direct and a bonus cross, depending on whose witness it is, if you want to. Sometimes there's no follow-up after a juror question. Lastly, on that policy, it may well be a valid objection to say asked and answered. I asked the witness 2 times, what color shirt did he have on? But if a juror has a question, what color shirt did he have on? I'm gonna ask it again because it means that juror somehow wasn't paying attention, didn't hear it, missed it. And that's an objection that I'll overrule. But otherwise, all the standard objections apply. You'll see that oftentimes the questions are something that they expect ought to be coming, and they just have the wrong witness. Did you fingerprint the scene? And it's the responding officer. And so we may just skip that question because we know that a crime scene technician is coming later. That's it for procedure. Ms. Willingham, how long do you think the state's presentation will go?
No more than a week, but I honestly think it could probably be done by Thursday.
By Thursday. Wednesday is a half day. I have drug court in the morning, so we will start around noon on Wednesday. So that probably pushes you into Friday.
And that actually may work best for the state anyway. I did forget in just a housekeeping matter that my lead detective is actually not gonna be able to testify at all on Wednesday. Because he has a dentist appointment and will have Novocaine and not able to talk. So, we would need to take him on Thursday.
I would object.
So.
Here we go. Okay, well, Wednesday morning is yours. We'll be doing drug court in here till about noon. So, okay, and in terms, well, I'll wait till Mr. Hairston is out here to say how long would a defense case go?
Is the court typically starting at 9 or at, okay.
Is that bad?
Well, so there's something that's come up in the Banks household that has caused me to shift and take my child to school every day.
Okay,
And so I've been responsible for that. And so, you know, that means I drop him off at around 8:50 and can get to the courthouse because it's right. I can get to the courthouse around 9:15. I'm trying to look for alternative opportunities for that to happen, or arrangements, but yeah, let me try to figure that out, Judge.
okay. Well, we have Mr. McCrimmons who will be ready to rock and roll.
Yeah, he's made up a look, and I'm sure Mr. Harrison probably likes him a little bit more than me, right? So,
Okay. Well, I'm single parenting this week, so I may be cutting it pretty close to 9 as well. And I think there's an orthodontist appointment tomorrow, so we'll talk about arrival time. But well, Wednesday's not going to be a problem.
okay.
So it would be Thursday, Friday. Tomorrow, we may say, let's just have the jurors be here at 9:15. Jurors are never here on time the first morning anyway. Hey there.
Hi there. Let me just go easy. The clothes are just. Mine's close.
The clothes don't fit. So, darn, like everything?
Everything.
Okay,
I was given the sizes by, so let me tell the court what happened is the mom sent some things. I never got those things.
oh, and then mom sent some sizes.
Then the mom sent some sizes. I was out shopping yesterday. And
All right,
I got what the sizes the mom sent. And so I think the pants should fit.
okay. Are you able to what, do we need pants and shirt? Note to self, do not let Mr. Banks be your personal shopper.
Well, I mean,
Okay,
I'll mess it up. I should have had the criminals do it.
what's the Massachusetts connection? How did you end up working in Massachusetts?
When I was in law school, my clinical professor was from Massachusetts and worked with Massachusetts public defender, knew that I was applying for public defender options.
Got it. So that was a natural pipeline.
Right.
So you took the Massachusetts bar?
I did. I didn't have to initially take it. They had a rule that allowed for you to practice as long as you were doing public interest work for up to 2 years. And then I took it after that.
Okay.
Coat and pants.
Shirt fits?
Only the shirt.
Shirt fits. Okay. Um, okay. I need to know what size he needs to get it from. We have a clothes closet that we can use. He's going to come up. Okay. All right.
Yeah, it's like. No, better. Yeah, that's fine. Deputy Gordon, tell me what we need.
I'm gonna just sit right there and, you know, what shirt.
Okay. You think there may be something right in there? We're also checking with Ms. Chapman down the hall who runs the clothes closet, but if we've got something there, that would work. Thank you for being the haberdasher.
We talk more about the add-on questions.
You talk about the voir dire? Yes, when Mr. Hairston comes out, we're going to sign the indictment with the not guilty plea, so issue's been joined. And then we turn to fleshing out the voir dire. I don't know when the jurors are going to get here. It's a super busy day for jury services, so I wanted to get our request in, so we're in the queue. but we'll use all the time we have to then go to the motions in limine to cover that. That's just in that room? All right. Thank you. Above and beyond.
Just off the tree.
Mr. Banks, for the rest of the week, do you need to get a different size? Is the family sending something different or?
I'll find out what size he is.
Yeah.
And I can go and exchange what I purchased and have.
Get the correct size or a size that fits
He's got
better.
some ties and stuff and that I bought him that he should be able to wear.
Okay.
He's got a couple shirts back there. It's just the suits that apparently don't fit. But,
Okay.
I could try to rearrange those. I think the problem is K&G. I think the pants are definitely too big. I knew that his mom told me he was a 36, but I knew he wasn't a 36 jacket. And so I thought he was a 38, but apparently he may be a 40, 42. But his pant size is not going to be a 40, 42. And with K&G, you got to buy, I mean.
Oh, they have to mat? They got to be this, you can't get separates.
Yeah, I knew that. See, Mr. McCrimmon doesn't shop at K&G, so
No.
I mean,
He's a Nordstrom, Saks.
Saks.
Yeah.
Whatever, I don't know. That's too
Yeah.
fancy for me.
You pay your associates too much, man.
Well, no, I mean, look, he's paying my salary.
Yeah. Attorney Wood,
You know what happened with the trial in front of Judge Hairston last week?
it's not done.
Oh, okay.
They are wrapping up today. Couldn't quite fit it in through Friday because it was a shorter week.
That's right. Thank you.
So he's back. No one wrote me back as to whether he has a court reporter. I hope he does because they had only booked one through Friday. But that's it.
I'm doing an all-out mission. I'm a conclusion. And that's the phone name. Because I was doing a lot of e-filing that day for the exhibits. And so I was wrapping that by the time I saw your call, I didn't realize until I saw the text message that you would have got it. I was calling.
Oh, like, who is this guy?
Yeah, and I was like, do you know how to find a person using just the phone number? It was crazy. This is like 8 o'clock at night by the time I saw the text message, but anyway, it all worked out. I was so embarrassed. I think you had the cold. So
I did. I sounded different. Yeah.
And then, like, I never say Robert, so I was like, who's Robert?
Who was that?
So I'm all through the directors. Trying to figure out who Robert is. Because they had returned a couple of my envelopes, so I thought it was someone.
Oh, from the clerk's office.
Yeah. I mean, who is it?
It's fine. Still pays it, because I'm really bored. I'm like, did I misread it?
According to the dome meat is 45.
45,
You forget the actual 33.
33.
We should do. Oh, okay. Right.
Great. Yes. Great. I thought it was like mid-March. Oh, she was on the right. I forgot.
We're good? Great. All right, let's get back on the record, please. Deputy Gordon, thank you for your work in tracking down clothing for Mr. Hairston. Mr. Hairston, Mr. Banks and his team worked to get you some clothing based on sizes that your family provided. And you've gotten bigger or smaller, I don't know which direction, since you've been in custody. So Mr. Banks may work off of the sizes of what you're wearing now, which looks very sharp, to get additional clothing. But we are able to move forward at this point. Ms. Willingham, I'd ask you to come up here to grab the indictment. Mr. Banks, I have a copy of the indictment. It's taken the last couple pages off, which just listed witnesses and some things. But what I'd like the two sides to do is enter the not guilty plea and sign and date it. So we've got that.
Yeah. I made it.
Please. Thank you. Mr. Banks, during the break while Mr. Hairston was getting dressed out, I asked, you were here for this, I asked the state how long they envisioned their presentation to go. The answer was Thursday, probably into Friday, especially when I explained that Wednesday would be a half day. Other than the variable of whether Mr. Hairston testifies or not, how much do you see adding to that estimate so I can let the jury know what to expect?
I think we could get it done in a week, Judge.
Okay.
This week.
All right. Well, what I'll do is let the jurors know that our expectation is this week, but it could spill over into Monday so that if someone was leaving town over the weekend and not coming back, we'd want to know that. I have witness lists from both sides, although it sounds like Ms. Willingham, you have one name you want to add to the state's witness list?
Yes,
And this is something you've shared with the defense?
yes, Judge.
Okay, and what is that name?
Katrina Ostapovich.
Katrina, can you spell that last name?
I sure will. Ostapovicz.
Okay, Ostapovich. And what is her connection to the case?
She is the forensic serologist.
Okay, GBI employee. Did she replace, you have 4 or 5-ish folks, is she replacing one?
Not necessarily, Judge. I know that Mr. Banks and I have had some conversation about possible stipulations as to some of those reports. So it is possible all of those GBI people will not be called,
Okay,
but for safe measure.
sure. We'll qualify the jury as to each of them to include Ms. Ostapovich. And then Mr. Banks, I had from your witness list, 2 more APD officers, a D Reynolds and a Q Reynolds.
This should be D Reynolds, and not just Q. I put, because I couldn't make it out whether it was D or Q from the body cam footage. And
Okay.
I didn't draft a report.
Okay, we have footage from a Reynolds and it turns out it's D, not Q.
Yes.
Okay.
It was kind enough to let them.
Excellent. Okay, well, I'll qualify as to D Reynolds as well. Ms. Willingham, if you could, especially now that you have 2 other trial partners, have for tomorrow morning, the beginning of an exhibit list. I know those are things in flux and whatnot, but it's real helpful for me to keep track of what has come in and what hasn't, to have something like that. Excellent. You need to have more cases in here. Thank you. All right, let's talk about one last procedural thing. Mr. Hairston, if you ever need to use the restroom, let your lawyers know. We need to get everyone out of the courtroom for that to happen, and we'll take breaks as we need to. We're going to take a few breaks during the course of the day. Usually that's enough for everyone, but if you are not able to be focusing because you need a break, let Mr. Banks or Mr. McCrimmons know, and they'll let me know, and we'll get the jurors out of the courtroom, okay? We will take a break between each panel. We don't have a full-blown lunch break today. Today is a little bit of a slog because the goal is to get the jury all in one day, and we're gonna be starting a little bit later because of our clothing hiccup. So there will be time to get a snack or whatnot in between each panel, but we won't at noon or 12:30 break for an hour. The jurors get that kind of break, but we don't. But every other day this week, you will have the standard hour-ish lunch break. Exception would be Wednesday because we're starting at around noon. You need to take your break before we get rolling. So let's start with the motions in limine, and we'll start with the defense motions. There are 7. Have you, Ms. Willingham, discussed with Mr. Banks any of these such that some of them are not an issue because you're not going in that area, like having Ms. McCoy talk about guns were stolen, or these are all things we need to work through?
Ms. McCoy is not at issue, and she won't be testifying.
Okay, so that can be denied as moot, or if something changes on the state side, you would let me and Mr. Banks know in advance so that we could have a discussion outside the presence of the jury. We have 51 coming. Yeah. So right now McCoy is not an issue.
Correct, and as to 7, I don't, that is not testimony the state was planning to elicit.
So we're clear on the record. This would be testimony from Ms. Brown, who's the victim's mother, talking about a discussion she had with her daughter the night of the incident? Or thereabouts?
Specifically as to what Mr. Banks's motion addresses as part of that discussion, because there will be testimony that she did speak with her daughter at the time that the defendant entered the home.
Okay,
But I don't expect to get into the defendant taking walks. That wasn't something the state was planning to elicit.
okay, so the areas of concern that Mr. Banks flagged, you plan to stay away from?
Correct.
Okay, and you'll let Ms. Brown know that she shouldn't stray into those areas. You won't lead her, wouldn't guide her in that direction, but she shouldn't be talking about that.
Correct.
Okay. Mr. Banks, anything you want to add about either number 5, which is Ms. McCoy, the state's not planning on calling her, or number 7, Ms. Brown, talking about interactions with her, conversation with her daughter the night of the incident? Sounds like those are both moot to me.
It sounds like it. I am somewhat concerned about number 7. Having said that, I can talk to Ms. Willingham off record and try to get some clarity from that. But I think that for the purposes of this motion, I think it is denied.
Okay, great. And I'm happy to revisit Ms. Brown's testimony if after you speak with Ms. Willingham, you still have concerns. But I'm hearing Ms. Willingham say, we're not going in that direction with that witness, but she will be testifying. How about the Uber driver? This would be number 4, an Uber driver talking about, and this one evolved a little bit. Now it's a AK-15 and a bag with lots of guns in it.
Yes, Your Honor. And the state would argue that that is relevant and the probative value is still outweighed. In this instance, the Uber driver, that is the beginning of the conversation. But the tail end of that testimony from the Uber driver would also address that the defendant made a statement to her that he was going to get rid of his girlfriend while having this firearm in his possession, that she also picked him up from the incident location.
Who's the Uber driver?
It's Deborah Allison.
Okay, so Ms. Allison is who we're talking about, and she drove Mr. Hairston just one time?
Just one time.
Days before the incident?
2 days before the incident.
Only 2?
Yes, 2 days before the incident, she picked him up from the incident location, actually, which is where she picked him up from where the victim lives, which is the
400 West Peach Street.
Yes, and they then go to this U-Haul facility. When he gets in her vehicle, he has this firearm in his possession.
When he gets in from 400 West Peach Street or after he goes into some storage facility?
400 West Peach Street.
Okay.
He goes to that storage facility, which she believes has firearms. We would not get into what her belief of what is in there or anything. But based on, I think it is relevant based on his comment while he's also in her vehicle. And to be fair, or with all candor to the court, Ms. Allison may also not testify, which then would end up making this. Ms. Allison may or may not be here. Should she be here, that is testimony that we would be seeking to elicit.
Okay, well, if she doesn't testify, it's definitely moot. If she does testify, I'm understanding that she's going to say, I picked up someone who I don't know. It's not someone I knew from before. Somehow she's going to be able to say it's the defendant. This was 2 days before the incident. She picked Mr. Hairston up from 400 West Peach Street and saw that he had on him a gun. Handgun or what says here AK-15, AR-15, a long gun?
Yes.
So she'll say he had a long gun. Okay, is that the type of weapon that is suspected to have been used in the shooting of Ms. Brown?
It is not that weapon, Your Honor, no.
Okay. And Ms. Allison takes Mr. Hairston to a U-Haul place and drops him off.
Correct.
And so anything she might say about, yeah, that storage facility had piles of guns, she's speculating, or she went in the storage facility with him?
Well, we wouldn't be eliciting that testimony. in reference to what's in that storage facility.
Okay.
Our testimony would be just what Your Honor said, in addition to the statement of the defendant.
Got it. Okay. Mr. Banks, now that you and I have heard the way in which the state would cabin the testimony, if this person testifies, tell me, not what your concern is, I wouldn't like it either as Mr. Hairston's lawyer, but what's the legal basis to exclude your client supposedly saying, I'm going to take care of my girlfriend, whatever the language was, and this observation that he had a gun, which it doesn't sound like it was illegal for him to have a gun. So she could also say he was wearing an Atlanta Braves baseball cap, or he had a big knife on his belt. These are things that I observed.
Sure. I don't know if I have a legal basis for the statement that he made to her to keep that out. I do believe that the description of the AR-15 style weapon is a problem, because I do believe that the prejudicial effect is outweighed by any probative value. One, the AR-15 is not the weapon that was used in this case. I do think that if she wanted to suggest that he had a firearm, I think that that would be fair, right? Because it would, if we're pleading not guilty, the issue of whether he had a firearm or had access to a firearm would be relevant to the jury's consideration. The style of this firearm is a lot different than just a handgun. I mean, you know, assault rifle, a machine gun, so to speak, can have a different appeal to a jury than just a firearm. And so I do believe that because it was not the weapon that was used in this case, the mentioning of an AR assault rifle would be prejudicial to this jury, and it would cast a bad character against Mr. Hairston that should not be inserted at the trial. Also, as it concerns her belief, he had a bag with him apparently, according to the witness, and she is speculating not just about what's in the facility, but also what is in the bag. And so I don't think she should be able to say, oh, there's a bag and there are a whole bunch of guns. And by the way, there's a facility, and I think he had more guns there. And in fact, my understanding of Detective Demeester is that he talked to her, he determined whether or not he had even probable cause to go and search the facility, and concluded that he did not.
Mhm.
So, I mean, if he didn't even have probable cause to get to there because it was unrelated to this incident, I think that poses another problem.
Okay. And you said that the assault rifle was not the weapon used in the incident. And we know that because of the caliber of the projectiles.
The gun was recovered
Okay.
from my client's bag. It was a handgun, as I understand it. It was tested. It matched the scene. And
Okay,
so,
got it. So there will be testimony that basically excludes it, meaning an assault rifle, as the potential murder weapon.
That's correct.
Okay. Ms. Willingham, I forgot to ask you about the possessed a bag that she believed contained multiple firearms. Is that also something you'd be staying away from should Ms. Allison testify?
Yes, Judge, we would be staying away from that. And just to go back, Your Honor, to the description of the weapon. Ms. Allison ultimately contacts law enforcement after she sees that this case is pending, primarily because, not just because of the defendant's statement. What Ms. Allison will testify to is actually that hearing his statement alone, she just thought that meant he was gonna break up with his girlfriend. However, in conjunction with him having this weapon is what ultimately caused her to then contact law enforcement after seeing that his girlfriend was now deceased. And at that time, Ms. Allison had no way of knowing what weapon is used, just simply that he was in her vehicle with a firearm and that he made this statement.
Okay. But if she testifies, you would limit it to that he had a firearm and I think his bag had more guns in it, and I think his storage unit had more guns in it. I mean, unless she saw guns in the bag, it sounds like it was speculation.
Your Honor, we would just add that her being able to describe it would go towards her credibility. So we would not want to stay away from it in terms of the description. As far as what is in the bag, that is something that we have already prepared to we already recognize where that can go, and we've already prepared to stay away from that.
Okay, and that's what I was getting at, is that you do not intend to ask her, did he have anything else with him? Well, we guess he had a bag. What do you think was in the bag? Well, it must have been more guns. That's not where you would go with Ms. Allison.
Correct.
Unless her testimony is, he opened it and showed me, do you want a Glock? Do you want a Taurus? I happen to have a bag full of guns.
Correct.
Okay, which is not what happened.
Not that we are aware of, no.
Okay, well, if that changes, you should let Mr. Banks know about that as well. Okay. I'm going to deny, given the parameters that Ms. Willingham has shared, I'm going to deny motion to eliminate number 4. Should the state call Ms. Allison, it sounds like that's up in the air, she may testify to what she heard Mr. Hairston say, as well as testify as to what she saw in terms of the weapon. We don't need to dwell on it a ton, but if she describes it as an AR or AK style rifle, that's what she describes it as. That's her recollection. And whether the jury credits that recollection, I don't find that a description of a gun that actually wasn't even the murder weapon or potential murder weapon is unduly prejudicial, and 403 authorizes me to exclude it only if that undue or unfair prejudice substantially outweighs the probative value. And to Mr. Banks's point, it's not super probative because it wasn't the weapon that was found in Mr. Hairston's bag after he was taken into custody. But I think the fact that he was describing what he described he was going to do to his girlfriend while he possessed a gun reaches a level of relevance that it does come in. But I'll note that.
If I may, just for the record.
Sure.
And I don't know if I got that out, but I think Ms. Willingham said it in real time, however. And this is why I don't think it's probative at all, because in real time, she thought that the statement, even though he was in possession of the gun, was that he didn't intend to off his girlfriend, but rather he was just going to break up with her. And so all of this analysis is Monday morning quarterbacking and said, oh, by the way, you know, I saw him with this, but in real time, that's why it's not really, in my opinion, relative.
Okay.
Relative.
And I thought this was maybe weeks before, but the fact that it was 2 days before or close thereabout, I find that it is sufficiently connected and relevant that if Ms. Allison is called to testify, she can talk about those things. We'll keep going with the motions eliminate, but I forgot we need to talk about voir dire because we may get jurors sometime this morning, and we should be ready for that. I'll start with the state. Were there any questions that you wanted added that I did not include on the list, or any that you want removed that I had included?
No, Judge, just argument as to the addition by defense. So I don't know if you want to take them up first and then hear my argument on that. But
I'm going to turn to Mr. Banks and Mr. McCrimmon's next. All right, Mr. Banks or Mr. McCrimmon's, based on what I sent yesterday, is there anything that you think should be removed?
I don't think anything should be removed, Judge.
Okay, how about added?
Yeah, this morning I filed another request that the court include a statement, has anyone ever blacked out such that it resulted in memory loss? I think that that's an appropriate question that doesn't necessarily pre-try our strategy. I would also ask this court to explore the jury's familiarity with voodoo specifically, and with it's called a shaman or a shaman.
Shaman?
Yes, shaman.
Can you spell that for me?
S-H-A-M-A-N. I'm understanding the blackout question.
Yes.
And I'll hear from the state on that in a minute. Tell me the relevance of voodoo and shamanism or a shaman to what the jury will be hearing about.
The latter is, according to, my understanding is that the victim's mother had a conversation with her on the night, and that shaman was referenced during that conversation concerning specifically the defendant. The voodoo.
Meaning, I just want to make sure I follow this. So, meaning, Ms. Woods, Brianna Woods said to her mom, something about shamanism or a shaman in connection with, Ms. Woods's interactions or conversations with Mr. Hairston.
Ask her mom to contact the shaman.
Oh,
On
okay.
behalf of Mr. Harrison.
Okay.
Not on his behalf, but at her request.
Right. Hey, could you get a shaman? I don't know what you call Mr. Harrison, but he needs some help, or this could help him.
Yes.
Okay.
It's also my understanding, Judge, is that Miss Woods did practice voodoo. And that may be a subject of, that may be an issue that will be explored during this trial.
And you would explore that through what witnesses, since Ms. Woods won't be here?
Her mom,
Okay.
the crime scene technicians and or the meester about what they found at the scene.
Okay.
My understanding is that there was a shrine in the apartment at the time that the scene was photographed, and there may be potentially another witness that that testifies to it in the event.
Okay. And relevance to the defense, the case for shamanism or shaman or voodoo. There also could have been on the wall a poster of Whitney Houston. And I guess you could ask a witness, well, what's that? But how is it relevant that there was a shrine, maybe a voodoo shrine in the apartment?
Well, I'm happy to talk about that.
It's part of the defense.
It is.
Okay, that's all you need to say? I'm not asking you to reveal more than that, but you wouldn't just be asking to get jurors intrigued by what the heck is going on. There's an angle to it.
There is.
Okay, all right. Ms. Willingham, you've been anxious to talk about these questions.
Judge, first, the state would argue that it is asking the jury to prejudge the facts, at this point.
Which question?
Well, as to both, because even from the defendant's, even from the question of the blackout, first off, I guess the question would be that if you view the body camera, the defendant does not appear to be blacked out. So that would have to come out through testimony. That would have to come out through facts that right now the jury doesn't have. And so we would argue that it's asking them to prejudge evidence at this point regarding the defendant being blacked out.
Okay.
Furthermore, as to the voodoo, I think again, you're getting into the facts of the case that you're asking the jury to prejudge in terms of whether Brianna participated in voodoo or not. That's not something, first off, I know that Mr. Banks has mentioned that that's something she asked her mom. Again, that's not testimony the state plans to elicit from Miss Brown. So I don't think that would be needed at this point. I don't know what Mr. Banks plans to, where else he plans to elicit that from. I take that back because he did just mention in looking at the, or having to speak with Demeester or the crime scene techs over there. But again, I think that at this point, it's asking the jury to prejudge the facts. Okay.
I will tell you the questions that I'm gonna ask, but I'll weave all three of those in. I don't view those as prejudging so much as figuring out, are there jurors who happen to be familiar with something in the same way?
What was the third?
Shaman?
And voodoo and shaman.
Oh,
Yeah,
okay, you're splitting
right.
those up into two.
Correct.
Okay.
They're not the same thing.
I just wanted to clarify.
And I'll tell you what the three, I'll write the questions out and make sure they basically just need to open up the topic, and then both sides will be able to explore it. I'm not gonna say, raise your card if you know about voodoo and then tell me what you know about it. I'll just say, are you familiar with the practice of voodoo? Words to that effect. But just to make the ruling, I view those as questions of exploring whether jurors have familiarity with something in the very same way that if this was a case that involved a car crash, you might ask, has anyone ever been involved in a serious automobile accident? That's not prejudging the case. You just might not want a juror, or you might want a juror who has had experience with that. The question will not be, does anyone think that blacking out is a justification for doing something? That's not where we're going. But let me find a place to ask them. Mr. Banks, with the shaman, what kind of question were you thinking of? Because it's not a vocabulary quiz. Does anyone know what a shaman is? It would be, are you familiar with the practice of shamanism? In the same way that I say, are you familiar with the practice of voodoo? Or what did you have in mind?
That's what I mean.
Okay.
That broad topic question will capture it.
Okay. So what I propose, Mr. Banks, is towards the very end, there are a series of questions. Have you or has someone close to you? And after the last one of those is, have you or someone close to you worked as a prosecutor or a criminal defense attorney? Then I'm going to insert your three questions. The first would be, have you ever blacked out such that you could not recall an incident? Then, are you familiar with the practice of voodoo? And then, are you familiar with the practice of shamanism? And then we pick up with, do you have any formal legal training, et cetera? You all right with that?
Yes, Judge, thank you.
Okay, Ms. Willingham, I know that's over the objection of the state.
Yes, sir.
All right, anything else, Mr. Banks, on the voir dire?
No, Judge.
Okay. Deputy Gordon, do we seeing anyone out there? Not yet? Well, that doesn't seem fair.
You said there are 51 jurors?
Yep. Well, we're still going to talk. So if this will take a little while when they show up to line them up. I'm just reaching out to make sure we can. All right, Mr. Banks, if we get back to your motions in limine, you had a concern about graphic crime scene and autopsy photographs. That is often an area of concern. You know the test, it's more, so are there too many of them? Do they serve a purpose? I don't know if you have spoken with Ms. Willingham as to if she's identified, hey, there are 5, I'm only gonna use 1, but I'm entitled to use 1. And you're saying, yeah, as long as you just use 1, I don't like it, but I know you're gonna get to use 1.
I think we can talk about that.
Okay.
And what I have her exhibit list now, so I'll just take a look at that.
Yeah, and come back to me, because if you feel like there is an excess, it sounds like from what I've begun to glean, the nature of the allegations, there are going to be some pictures that are rough. And so it's just a question of quantity. And if there's a good faith reason to use each one that Ms. Willingham wants to use, that's different from here's the 19th angle of something that we don't need a 19 angles of. So I'll table that for now. One other question about voir dire and then back to the motions in limine. How do I describe where this happened? I put in there 12 downtown, I typed in that address and it listed Mellow Mushroom, which is where Mr. Hairston was taken into custody. But Ms. Wood's place, it wasn't a hotel.
No,
Did it used to be apartments or it is also apartments?
it is condominiums.
What's it called?
And that is, because that's actually exactly how the property manager is going to describe it. It's 12 condominium. Hold on one second. Yes, 12 Centennial Park condos.
Okay, so I will not say 12 downtown hotel, but I will ask if anyone's familiar with that building it's the intersection of West Peachtree and Ivan Allen.
Yes.
Okay, 12 Centennial Park condos. All right. Okay. Mr. Banks thinks that any body worn camera of an officer entering the house, meaning I assume the condominium at 12 Centennial Park condos, should be excluded. Mr. Banks, tell me, let's deal with 2 and 3 together. Body cam of making entry and life-saving measures. You can go first.
I don't necessarily think we need to deal with 3.
The life-saving measures?
Correct. To spare the jury, we would not actually be playing that portion of the body camera anyway. The officer will be able to testify to what happened once they got into the home. So we don't plan to actually play anything that shows the life-saving measures at all.
Okay.
So I don't think 3 is
Okay.
gonna be an issue.
If that changes, let Mr. Banks know so that we can talk about it outside the presence of the jury. But for now, if you're playing body cam, you'd be stopping it before CPR, tourniquets, whatever is being done.
Yes, Your Honor.
Okay. What about the making entry into the home?
Making entry, Your Honor, we would be playing that. As the officers arrive to the home, they get to the floor, they're told that it's the 29th floor. The way that they are able to confirm exactly which apartment it is by knocking on the door, and they subsequently hear the victim scream. You hear her scream as they come down the hall, but again, they're not able to determine exactly which unit that sound is coming from.
Okay.
So we would be playing that portion because that's ultimately how they determine where the victim is. So yes, the state would want to play that portion of the body cam.
Okay. And you'd play it to the point that they find which door it is? Do they break the door down? How do they get in?
It's actually unlocked. And
Okay.
they can push it open, but from where I have time stamped it, we would stop it before it gets there. In fact, there are multiple, she screams for help several times. I wouldn't even play all of that portion.
So it's more you are playing body cam footage of arrival at the door as opposed to entry into the unit.
Correct.
Okay. Does that change your concern at all, Mr. Banks?
It does. I talked to her a little bit about it. She kind of hinted at what she was going to do. And so if that clarifies my understanding of what she's going to do. I was a little bit unclear that she said at some point I would stop it there. I don't know what there is. And so I can talk to her about that. But
Well, why don't you circle back with me if where there is crosses a line in your mind, and then I can watch it and say that is, it's all relevant. I'm not asking why the heck do you need it. I just wanted to understand the context.
And it's something I would want us to circle back to rather quickly because it's also something I would anticipate playing in my opening.
Okay, well, but then that just means that today, share it with Mr. Banks or Mr. McCrimmons, and if one of them says we're good, then there's no circling back. It's good you have 3 lawyers on your side. And we covered the U-Haul. So I guess the last one is number 6, which is hearsay on body cams. And that's a complicated one because body cam is recording what's going on. And it could just be like, hey, what was in the closet? And it's just chatter and this and that. Was there something in particular you were concerned about? Because then Ms. Willingham could say, I'm not playing that part.
Well, there are some witnesses that come up to the officers that kind of talk about Mr. Hairston being in the mellow mushroom. I think that those statements would be a problem if the witness isn't here. I haven't scoured through her entire exhibit list. I mean, exhibit number 9, for example, while it wasn't on a body cam, it seems like an audio interview.
Some of those are not necessarily coming in.
Oh, I
unless
see.
We have to, unless the victim or the witness's statement changes or something like that, but for the purposes of making sure that we had it documented.
Oh, I see.
Got it. You might have it to refresh or impeach.
Correct.
Okay. But you've heard Mr. Banks's concern. Are you envisioning playing long enough segments of body cam that unidentified individuals are going to come up to the officer and say, hey, man, he went that way and he was saying the following things?
Your Honor, actually, the only body cam the state intends to introduce is the body cam where officers arrive at the apartment. So I don't expect that to be an issue at all.
Okay. If that changes, let's talk about it. But for now, then, to recap, starting numerically in order, crime scene and autopsy photos, I'm going to stay out of it. Mr. Banks, you'll bring that back up if you have concerns after you see what the state's going to use. The body cam footage of approaching the unit on the 29th floor sounds like is not going to elicit an objection. Mr. Banks just needs to see where you're going to press stop on that. The life-saving measures body cam the state is not using, so that's moot for now. I've ruled against the defense on Ms. Allison, the Uber driver, talking about what well, there was not an objection to what Mr. Hairston said. The objection was to the driver talking about observing Mr. Hairston with a gun and then claiming she knew what was inside his bag. I've allowed her to talk about what she saw. He had a gun. She can describe the gun. She cannot speculate as to what was in the storage unit or what was in the bag. Number 5, it sounds like Ms. McCoy, Mr. Hairston's former girlfriend, will not be testifying. If that changes, we'll revisit. Number 6, other body camera footage, there won't be any. And then finally, number 7, Ms. Brown, and that would be Ms. Wood's mother, she will be testifying, but the state says they do not intend to get into the areas of concern that are flagged in motion in limine number 7. Any other ruling you need in connection with your motions in limine, Mr. Banks?
No, Judge.
Okay. Pivoting to the state, from long ago, there was a reverse Jackson Deno filed, and I didn't notice that. Are you going to be using Mr. Hairston's statement?
No, Judge.
Well, that makes your other motion then make more sense, because it sounds like at some point Mr. Hairston told the police, I did this in self-defense.
Not quite told, well, yes, he does make a comment to law enforcement, but it is that this was self-defense, we would be seeking to keep that out. And the Jackson Deno was more so a question of making sure that we were all on the same page, that what the defendant says is actually not his statement. He's actually speaking to someone, not law enforcement at all. But we would also be seeking to keep that out, because during that conversation, he's talking to his brother-in-law while in the interrogation room. And again, he makes comments that this was in self-defense.
The state does not intend to introduce anything Mr. Hairston said to anyone with law enforcement. Okay. Given that, then that does create a situation for the defense in terms of would it be self-serving or not? And you're not, it's not a Rule 106 completion. You don't really get your client statements in short of him testifying. So if you agree with that analysis, then as long as the state is staying away from anything Mr. Hairston said to law enforcement or while in law enforcement custody, I think you need to do the same.
Yeah, I don't like that area of the law on behalf of Mr. Harrison, if I'm to be honest.
I
mean, it's,
appreciate your
I mean,
opinion.
all of a sudden, a statement becomes self-serving. I mean, if they felt like it was important enough for him to say, they would be playing it, and then all of a sudden, oh, well, we don't like what he said, and then therefore it's self-serving. It's just what he said to him. And so I don't like that area of the law, but I will follow this court's instruction.
And the court is merely following that area of the law and not making up anything new in that space. Of course, Mr. Hairston may elect to testify, in which case you'll be able to explore those things. Short of that, and for good reason, you, as the defense attorney, cannot get into things that he said to others unless the state opens that door. And it sounds like they're keeping it closed. The other motion in limine, Ms. Willingham, had to do with medical records. Mr. Banks filed the appropriate notification, business record certification, et cetera. And you pushed back saying, I don't think those should come in because.
Yes, Judge, and I'm gonna focus more on my argument regarding the self-serving, especially after speaking with Mr. Banks and kind of getting a better idea of where in those medical records he's looking to introduce evidence. The defendant is alleged to have had a concussion. When he goes to the hospital, the way they're able to treat that is because he explains that he was punched in the head or something of, and I'm sorry, I'm not looking at them right now, so I don't have the exact words.
But let me pause you. These medical records relate to what date in connection with, is it weeks before, 10 months after?
So the portion that Mr. Banks would be trying to get in would be, I believe it's June 2nd, so 2 days after, which we would argue that that statement in itself, the statement the defendant makes to seek treatment is still self-serving, as he would then have the ability to testify without actually getting cross-examined that someone punched him in the head, which would lead the jury to believe that that someone is our victim, and therefore we get back to his same argument of self-defense.
There's not more context to his statement of someone at the jail punched me in the head?
There's no other context to it. It just simply acknowledges how many times he was punched in the head. So it doesn't, and that's the issue with it, is you then have no way of being able to determine where that comes from.
Sure, right. Unless you called the witness to the stand, and you can't do that.
Correct.
Okay. We're getting back into that area of the law someone doesn't like. Mr. Banks, tell me, it may be that Ms. Willingham is looking at the wrong part of the medical records.
I do think that I am willing to introduce you the medical records. He was admitted to the ER at Grady on June 1st.
Okay,
This incident occurred on May 31st.
okay, so the next
Early
day.
morning hours. So he's in police custody. It's well into the evening before
Yeah.
he's transported to the jail. He's then taken from the jail to Grady. And so he's admitted to the ER at 4:48, according to these records.
On June 1.
On June 1. And
Okay.
so he's not at the jail for that long, frankly, before he's transported to the medical or to Grady. Having said that, he is diagnosed with a concussion. And so I think that's relevant to his defense.
Who is providing the testimony that that's what happened?
What do you mean who?
Well, unless you have a witness, I understand you get the medical records in, but then you may be able to get the medical records in. Are you just going to read from the medical? How is the jury going to find that out? Through what witness? Or you would be arguing you'd be presenting in your opening and arguing in your closing, hey, you should read these medical records. It will show you on June 1, right after this incident, he goes straight to the hospital and he's diagnosed with a concussion.
Well, I think that, one, I get them in because they're self-authenticating in their business record. I know the court understands that. But two, if they're in, I mean, I could publish them and I can read from them. And it
Right, I'm
says
just-
diagnosis. I don't have a witness
Okay.
necessarily. I will probably explore it with Detective Demeester,
Okay.
for example. He's the lead detective
Mhm.
and, you know, and so I think that that would be appropriate to explore.
Okay. Ms. Willingham, anything you want to add on that one?
Your Honor, I
Well, I want to break it into two pieces. First, the threshold question. It sounds like they are business records that have been adequately certified. And so we don't have a hearsay issue. It's going to be a relevance issue / a defendant statement can't come in absent you propounding it or the defendant testifying.
Yes, Judge, and that's why we are more at the self-serving argument. That's why I didn't make much argument as to the hearsay. But I do believe we're still at the same point with it being a self-serving statement. I know the only way I could even think of that could potentially get us around it would be essentially to redact everything from the medical records with the exception of he had a concussion.
Well, you say everything. I was thinking the redactions would be much more minor. Any part of the medical narrative that refers to things Mr. Hairston relayed to the doctor, that would need to come out. But I mean, medical records are usually 80 extra pages that say, and he got a saline solution and this and that, and they repeat things. But the nugget of what the patient-doctor interaction was, that's where I think you would be proposing redactions. And I think it would be appropriate to redact anything that appeared to be attributable to a communication from Mr. Hairston. But the diagnosis of concussion would be a doctor's opinion that I checked this guy out and he had a concussion. It's kind of floating out there, but that doesn't mean that Mr. Banks can't, in argument, say, look, something went on. I mean, he had to be taken to the hospital because of concussion. And you'd be able to argue because he hit his head on the side of the squad car when they were putting him in the squad car, or who knows.
And I think, Judge, that I think is the issue is that it still allows the defendant to create his defense without having to take the stand, because even showing that he has a concussion the day after this happens with no more context, I think does still allude to that same self-defense argument.
But let's say instead of a concussion, all we had was the booking photo of Mr. Hairston, and he had one big black swollen eye. He couldn't see out of that. Mr. Banks could say, look at that photo. Look at it. He got punched in the eye by Ms. Woods. And so, of course, he was defending himself. I mean, I don't know how persuasive that's going to be, but I don't think you'd be able to keep that photo out. The difference here is that a doctor has said concussion, but if it was instead bruising, and let's say he had what looked like nail scrapes across his cheek, that's still coming in if that's what was in the photo. It would require, to make it particularly persuasive, a witness saying, yeah, and she scraped me, so I pushed her back, and that's what happened. But Mr. Hairston doesn't have to testify, and I don't think Mr. Banks is required to get him on the stand to get some of those toeholds, is what I call it, for a self-defense argument. And you, in your closing, will be able to point out how persuasive it is or isn't. But I'm seeing this as akin to the booking photo with the big old swollen black eye. But instead, it's a doctor saying he had a concussion. And it isn't connected any more than that. And I suspect you'll point that out. Okay. What I'd ask you to do is identify in the medical records and this does not need to happen now because this is a ways down the road, someone on your team identify the things that need to be redacted, check with Mr. Banks, and if there's no disagreement, then we will admit an unredacted set into the record, but there'll be a set that will go back with the jury that's redacted. If there are disagreements about the redactions, I'll mediate that part and figure it out. For now, my ruling is that the medical records with redactions could come in. I'm happy to revisit it if you think about it more and say, well, you know what, Judge, here's an additional argument. And because it sounds like that's going to be a little ways down the road that they'd be tendered and a witness would be examined. Mr. Banks, anything else in connection with the medical records?
Yeah, just very briefly, the collection of medical records that I obtained from Grady have 3 separate dates: December of 2014, June 1st of 2023, and then July of 2023. Just for the clarity of the record, for the purpose of the guilt innocent phase of this, I would be seeking to introduce only the June 1st, 2023 portion of the records subject to the court's ruling.
That makes sense. I think the others you'd have relevance issues. And so if you could make clear to Ms. Willingham what the universe of June 1 pages are, then she and her colleagues can look through and say, here's what we think should be redacted. You can agree or disagree and we'll work through the redactions. But let's make sure we talk about that before you're tendering them. And it sounds like you wouldn't be tendering them until Demeester at the earliest. And since he's having dental care, we know he won't be here till Thursday.
Okay.
That gives you a couple days. All right. Well, it looks like bodies on the other side of the glass. Are they here?
Yeah.
They ready?
No, paperwork.
Okay, interesting. It's usually the other way around. Okay. Anything else we need to cover before we get our jurors? Ms. Willingham?
No, Your Honor, I think that's it.
Okay, Mr. Banks?
That covers it, Judge.
All right, Mr. Hairston, would you benefit from a quick break? Because the jurors are here, they're not going to come in for a few minutes. So if you want to get back there, we could do that right now. Otherwise, it'll be a little while. Okay, could we do that, Deputy Gordon?
Yes.
Okay, thanks.
Judge, I'm sorry, I guess I did have a quick thing. Did you send us the exact questions you were adding, or?
No, because I hand wrote them, but I can tell you where they are if you want them in sequence.
That's what I.
Sure. So the last of the have you or has someone close to you questions, which is about being a prosecutor or a criminal defense attorney. Right after that, I will ask, have you ever blacked out such that you could not remember an incident? Then, are you familiar with the practice of voodoo? Then, are you familiar with the practice of shamanism? Then we get back to, do you have any formal legal training? These jurors are going to be fascinated about what this case is about. All right, let's take a couple-minute break. We'll get Mr. Hairston back in here and get our 51 jurors in here.
Because we can go over those 3 copies of the updated ones. It won't have the actual question, but it'll be the 3 blocks with blanks.
Did you know how we're gonna do the, passes? Did you know how we're gonna do the passes?
Oh, yeah, I forgot about that. So he doesn't do it, so he does. So we will, so we don't, and we can first, we can first. We have to, we can't say just have to take it easy. Unless if there's something else, yeah, and then the second one they'll do, and then the third one will be back to us. With that said, I hopefully can do the first one myself, or if she get comfortable with it, you are welcome to it. And then the second, and then the third one, if you want to. You can, and if not, I can let that. Okay, okay, okay. So do you want to do the first one, or are you working on something? If you can follow, but then I'll do the second. And do the next one. I won't see it. Oh.
I've got those photographs.
Oh, yeah. Sorry. Because maybe you couldn't be the one. So, I'll do. I'm with it. We have to see. Well, the people in this. Okay, gotcha. What is the audio? Thanks. You know, I will. Because we have questions to over individual that. Oh, yeah. Yes. Oh, okay. I'm gonna go to this fall. Okay. So here's what the leaders and the people. I would just tell them it's really can't. That's good. You will be so good. It's the one.
We're making copies. We'll get you your set in a minute.
Good morning, Judge.
How are you?
Good.
Bye.
Bye, Judge. Oh, yeah.
Thank you.
I just had to close it out. Yeah. See the video when they're pushing the video.
Yeah.
Oh, it's too short. It's not. No, that's not it. That's not it. That's it. Maybe I'm going back at it. Okay, no, let me go on.
I'm from juvenile court.
I'm missing 3. 49, 50, and 51.
Oh, that says something. I mean, they're all at the very end?
Yeah.
Huh, okay, did we let,
No, I'm about
you're gonna tell them? Okay. It's like they've skipped one page.
They want to turn in cheese.
Oh, yeah, you all should rotate around the table. If you'll roll a chair for Mr. Hairston, please.
He's calling.
She's calling? Okay. The screen?
Yeah.
Yeah, you know what? There, now you don't even have any liability. Assumption of risk, all Gordon. How are we gonna know when they show up? Oh, what the answer was?
She said it.
Okay. It's good that it's the last three, because if they can't find those, they can just generate another three. I think they can't give them the same number, but we just get 52, 53, 54, and those would be our last three jurors. I think they just forgot to call those three names up downstairs.
Otherwise, 49.
Could be. Yeah, I figured based on employer, like you have to be kind of old. I haven't been around.
So we have 50 and 51, 49.
Let's go. Okay, let's just bring everyone in, please.
Judge, they found them and they're on their way.
Okay, we have two of them. We don't have number 49, but we're gonna get started. And if 49 makes it, that's super, but it's 11:30. We're gonna be here till midnight. Not really, Ms. Rivers.
All right, for the jurors. All. No, follow the line, follow the lines, thank you. Yeah. Audio is present and the council on.
One is missing? What number? 44. And 49 is here?
He's there.
Great. Just waiting on one juror to join us. We'll get started. You all can be seated.
Who is the president of the county court?
Thank you, Deputy Gordon. Good morning, everyone. Thank you for your patience this morning. I know there's been a lot of hurrying up and waiting down on the 7th floor, but you are now in courtroom 8D. I'm Judge Robert McBurney, and I am presiding over a criminal trial for which 14 of you will serve as jurors. We are going to spend most of the rest of the day together working through a process called jury selection or voir dire. And it's important that you're here. I know you all had other things you could be doing, but this is today the thing you should be doing. You got your juror summons and you showed up, and you are about to participate in a process that's very important to both sides in this litigation. It's a criminal case, so it's the state versus, and in this case, the defendant's name is Mr. Hairston. And your presence here is important to the state, and it's important to Mr. Hairston because there are some criminal charges to which Mr. Hairston has entered a plea of not guilty, which means there's an issue that we need members of our community to resolve. And that's what the jury in this case will do. I'm going to tell you a little bit about the case and ask you some questions. Then the lawyers are going to ask you some questions as we learn a little bit more about your fitness for this case. More on that in a moment. I've introduced myself, Judge McBurney. Deputy Gordon is my bailiff. He will be here throughout the trial. If you're selected to serve, you'll see him throughout the week. Ms. Rivers is my court reporter. She's seated in front of me. She'll be in court and very busy anytime anyone is talking, whether it's you or me or the lawyers, because she's making a record of everything that is